It's a little crazy with the kid and the dog.
I can't get my video to work today.
That makes me look adventurous.
Oh, sorry.
Oh. I know. Oh no.
Welcome to Bankruptcy.
That was the worst ever. That was so bad.
Hi, everybody. Welcome or welcome back. If you were just in our last session, then I'm sure you're getting sick of seeing me at this point. We are here for our session with Matt Hartley, and let me pull up our welcome slides here. The second of 4 sessions that we have today, and I just learned that this is pronounced Bifurcated Bankruptcies with Matt Hartley. So I have a couple of housekeeping notes for you. Obviously, if you've attended any of our other sessions, this will sound familiar, but if anybody is new, we'll go over for the first time. On the right-hand side, you'll see that there is a chat window, which you can use to communicate any technical issues, or you can also talk to fellow attendees. We also have our moderators, working on the back end to try and answer your questions as best as we can throughout the presentation, but we will also have a Q&A as Matt wraps up, probably in about 40 to 45 minutes in. I'm not sure if there are any polls for this session. Looks like there are, so you can actually see those under the polls tab on the right side too. We have a code of conduct to use inclusive language, no threats or intimidation, no offensive comments. We're really lucky to have Matt here with us, so we want to make him as comfortable as possible. You can just sit back and enjoy the show. So we are here, I have cards, for the Bifurcated Bankruptcies. And as bankruptcy attorneys, you will have clients who can't afford to pay some fees up front, and which brings us to this session where Matt will be going over a lot of the details, including documentation, collecting payments, etc. And he will be helping you get started and also letting you know how Fresh Start Funding can help you as well. A couple of stats before we get started. Since the pandemic had begun, about 3 million people are not paying their mortgages for whatever reason, and some of those reasons could be that a lot of small businesses have had to shut down, about 24%. Also, about 22 million people have filed for unemployment, unfortunately. So during the last recession that we saw similar to this, bankruptcy filings were up about 74%. So that is why a lot of experts in the field feel that we could be headed toward, this buzzword again, a tsunami of bankruptcies. And since we are a software company in the bankruptcy field, we have a lot of firsthand information and experience ourselves, but it's also why we felt that it might be a good idea to put together this week of conferences and to invite experienced individuals and professionals such as Matt. And so I would like to give him a little bit more of an introduction. Also a reminder, if you were in our last session, I will say again, we might also be hearing from my neighbors today. They are not MCs, they're not presenting, they are just loud and they're all around me. So back to Matt. Matt Hartley Esquire is a leading expert in bifurcation. He started Fresh Start Funding to provide attorneys with better financing services for their clients. Prior to starting Fresh Start Financing, Matt owned and operated one of the largest consumer bankruptcy law firms in the country. He has personally filed thousands of bankruptcy cases, and now he is here with us today. I have hit the invitation to join us on stage, and now we're just waiting for that to go through. So I'm stalling. Really good. Hi, thank you so much for joining us, Matt. I love that
Hi.
background.
Oh, thanks. Yeah, I hadn't seen the introduction yet that you ran. I thought it was really funny and completely relatable. I am in our office today. This is our studio where we do a lot of webinars from, but the last month and a half or so, I've been fighting off the dogs and the kids and the like, and it's just the new norm. I mean, it seems like every call is interrupted, but today should be well because I'm the only person in this big office, so we should be there's no one here to bother me.
Good. Would you say one person in particular in that video was funnier than the other? You know what? This isn't about me. No, coincidentally, our last speaker actually had her dog join her unexpectedly toward the end. But thankfully, we have you, and it's just you. And unless you need anything else from me, I'll hop off stage and I'll let you do your thing.
All right. Sounds great. Okay, well, thank you everybody for joining me today. I really appreciate the opportunity to speak with you about bifurcation. We started this company a little over 2 years ago, and webinars have actually been a big part of our communication process out to attorneys around the country. And it continues to amaze me the interest, how it's grown so much. We have more and more people attending webinars, and because more and more people want to know about it. But we started Fresh Start Funding to make the fresh start of bankruptcy affordable and accessible to everyone. There's some real challenges out there with people needing to get access to justice, access to the bankruptcy system, and people just can't afford to pay their attorneys up front. And we have a solution for that. Fresh Start Funding, the two founders, myself and my partner Dan Garrison, were both attorneys with almost 3 decades of experience each. We both came out of the big firm area, both were a little disenfranchised with being in big firms. As mentioned earlier, I did have my own consumer bankruptcy practice, and one of the biggest in the country, and helped lots of people with getting their lives back in line and their financial lives back in order. But one of the big challenges always was having people able to pay me for my services. And it's just a real problem, as you can imagine, for people who need to file bankruptcy. So since we started Fresh Start Funding, though, we do work now with over 400 law firms around the country. We're in almost every state in the country, and we continue to grow. We have a lot of expertise that we're happy to share with attorneys, ones that work with us and ones that don't. But particularly the ones that are in our system, we have lots of things to really help you with your practice. So let's talk a little bit about what bifurcation is, and I'll get into more details later. But what bifurcation is a way for attorneys to get paid post-petition. So the issue traditionally was that if an attorney had signed a fee agreement with the client, then they filed the case, and then they tried to collect their fees. Well, their fees they're collecting are pursuant to a pre-petition contract, and that thing is no more enforceable than a credit card obligation. So as the attorney, you technically cannot collect those fees, and if you do, you're violating the automatic stay. And so that's a big problem. But what the result of that is, though, is it's really kept a lot of people out of the ability to file bankruptcy. There's been a lot of studies on bankruptcy, a lot of articles on it. In fact, there was a great one, if you want to read over 100 pages of analysis, but there was a really good article in the Notre Dame Law Review last year that really detailed the challenges that people have who can't afford to get a bankruptcy attorney. And some of the issues include, if they can't file, they're limited on their options. I'll talk about those in a little bit. But people are going without just true necessities. They're going without food. They're going without medicine. And the most basic things that they need to live, they're just not able to get because of the financial challenges they have in their lives. And in cases they studied, bankruptcy would have alleviated that. And so let's also talk about, people can file without an attorney, but the people who file without an attorney, the odds of them getting a discharge are dramatically less than if they have an attorney. Debtors represented by counsel almost all get a discharge. The percentage that don't is well less than 1%. But when you don't have an attorney, it just goes up dramatically. And even if you do get a discharge, for a lot of people filing on their own, they get some disastrous results. And they just don't know how to plan for bankruptcy because nobody's advising them, and bankruptcy is complicated. So not having an attorney is a big problem. And so it basically leaves people with a few options. One, as I mentioned, is to file without an attorney. One is to not file at all, which doesn't help them get them where they need to be. The other is fee-only Chapter 13s. And these are a bit controversial. There are locations around the country where U.S. trustees and the judges allow attorneys to file what we call fee-only 13. And that's someone who really should be in a Chapter 7, but they put them into a Chapter 13 so attorney can get paid. My personal view is that, that creates some real ethical issues. I don't think an attorney can do that. But there are some areas in the country where you can do that. But the problem for the debtors is it ends up being much more expensive. And as many of you know, in Chapter 13s, the percentage of people getting their actual discharge are very low. And then, of course, there's the classic layaway plans. And that's the client that comes in, meets with you, can't pay you up front. You put them on a payment plan, and they start making payments to you. And sure, some of them can pay pretty quickly, but so many of them can't. And I had many clients who would take a year or more to pay my fees before I had the zero down and bifurcated option for them. So there's some real challenges for debtors on all this. And there's also challenges for attorneys too. With attorneys, oops, I have to slide back up here. So I'll just keep talking here, but with the attorneys, the challenge is that, people coming and meeting with you, typically about 50% of the people can't retain you. And that was true in my practice, and that's true with attorneys we talk to around the country. About 50% of the people would love to hire you, but just can't. And sometimes they tell you they can't because they don't have money, but many times they say, well, I got to go think about it. Oh.
Hey, sorry to interrupt you, Matt. I know that you had slides prepared for your presentation, and we wanted to make sure that we had those up and at least caught up to where you were.
Yeah, actually, I had no slides yet. I'm going to bring those in later. So I was just.
Oh, okay. We were sitting here thinking like we hadn't put your slides up yet.
Nope.
Well, in that case, I'll let you get back to it. Sorry for throwing off your rhythm there.
Yep, no problem. We'll get back. We'll get to the slides in a little bit. I just want to give a little background first before we do it. And so what I was talking about is the challenges for attorneys. So we talked about the challenges for the debtors. The challenges for attorneys is that, again, only about half the people can retain you that come into your office. You're losing half your business walking out the door. And then for the attorneys who do decide to offer a bifurcated arrangement and to collect fees post-petition, if you're not working with somebody like us, you have some challenges there too, because first you have cash flow issues. If you get paid up front, it's much different than if you get paid over 12 months after you file a case. So most small firms, that creates a lot of problems. You have payment management problems. If you do, say, 10 cases a month, post-petition payments, people are paying weekly.
I'm so sorry again. We were having an audio issue, which is why I'm here again. I'm sure you weren't expecting to see me so often.
No, great.
Could you just test your audio one more time before I go?
Yeah. Testing. 1, 2, 3.
Much better. Thank you so much.
I'll slow it down to that. It may be part of the problem. So what I was saying, so the challenge for attorneys doing it on their own are payment management challenges. So again, if you're doing 10 cases a month, people are making weekly payments. By the end of the year, you have 120 debtors making payments, and they're making over 500 payments a month. So then you and your staff have to manage all those payments. And as you can imagine, with your experience with collecting in the under layaway plans, there's lots of changes to payment plans, lots of missed payments. There's a lot of management that goes into it to make sure those payments keep coming in. And so now we'll get into some slides. Okay, so let's talk about the services that Fresh Start Funding provides. One is we provide a line of credit. Almost all firms qualify for this, and it's used to mediate the challenges of not getting payments for 12 months. Also, then we provide payment management. We use a mixture of cutting edge technology and humans to make sure we get the payments in. I mean, the technology is great, sending out automated messages and having a portal for debtors to come in helps. But at the end of the day, it's really the human touch that really sets our payment management apart from others. It's the reaching out to people, making sure they have options. It's super friendly. It's the same manner I did it at my law firm. Nobody is pushed hard for payments. We just work with people because they do still have financial challenges oftentimes after they file bankruptcy. We also provide credit reporting for the debtors. And what's really cool about that is when debtors come to you, especially in that initial consultation, you can tell them that, hey, if you want to do this bifurcated option where you're going to make payments post-petition, we'll actually report those payments to the credit bureaus, and I'll be the first one to help you rebuild your credit. Because we all know these people, when they come in to file bankruptcy, they all have intentions of rebuilding their financial lives, rebuilding their credit. Many have goals of buying houses and cars and different things. I mean, unfortunately, some of them don't get there, but many of them do. But rebuilding their credit is a really critical piece of that. And as you know, filing bankruptcy doesn't really do much for credit. It's really, you need to start rebuilding that credit outside of bankruptcy. And then another important thing we provide is all the forms that you need to bifurcate. It is a very technical area. We make sure that attorneys do it correctly. And then we provide a very good training for attorneys and their staff to make sure they're doing it correctly. The last thing we do, and this is really becoming less important as we've moved forward, but we do have a defense guarantee and indemnity that we provide to all of the attorneys that work with us as well. And the idea there is that if you get questions from a U.S. trustee or a judge, we'll take the point on that. If there's something even goes to a hearing, we'll literally put an attorney on a plane to fly out and handle the hearing. Again, this is becoming less and less important. But there's still a couple of jurisdictions around the country where there's still some questions about bifurcation and the like, and we have your back. And then if it were to come to this, and it never has, but if ever a court were to disgorge fees, we will indemnify attorneys up to $50,000 for any lost fees with bifurcation when they work with us. Again, knock on wood, we haven't had to do that, but we don't anticipate having to use the indemnity. But there are some attorneys have had questions. But when I talk about the case law a little bit, you'll see sort of how things have evolved over the last 2 years. So let's talk about how bifurcation actually works and what it really means. So with bifurcation, you're splitting your services into pre-petition work and post-petition work. And you're doing it with 2 different fee agreements with your client. One you sign, obviously, before you file the case, so it's pre-petition. And the second one that you sign after the case is filed, and that one is for post-petition. And by doing that, it allows you to collect fees under that second agreement without violating the automatic stay and eventually the discharge injunction. Let's see. And then one thing you have to do with those, you have to reasonably allocate your services and your fees between the 2 agreements. We'll have a lot more discussion about fees because that's where you can get yourself in trouble. And then also attorneys that work with us, and most attorneys that bifurcate around the country, file what's called either a skeleton or a rush or a short case. And basically what the whole idea is, you're trying to push as much work post-petition as you can to justify the post-petition fee. So the bankruptcy code is very clear on what you need to file to start a case. It's just a handful of documents. And it's also very clear that you have 14 days to file the statements and schedules. So we have all the statements and schedules be prepared post-petition and filed post-petition. Now, important thing is that any fees for your pre-petition work, you either have to collect them before you file or they are waived because they're discharged. So again, for true zero down, you are doing work before you file the case, and you can collect money for that work. But really the true benefits and what most clients need is they need a zero down or a very low down option. So you're really not going to collect much, if anything, up front, and you're going to collect fees post-petition, but those fees post-petition have nothing to do with the work you did before you filed the case. It's only for the work that you did after the case was filed. And so one of the questions we often get is, if you're filing these rush cases or skeletons, what about all the required work the attorney has to do before they file a case? And the answer to that is that you have to still do all that work before you file the case. And so, as I'm sure you know, there's certain requirements in the bankruptcy code. Attorney has to make sure that the Chapter 7 is in the best interest of the client. And so, and that they're able to file Chapter 7 too. And so you have to do some basic work no matter what. You have to still make sure that they haven't filed a Chapter 7 in the last 8 years. You still want to pull their credit. Check there. You want to have, very detailed discussions with your client to try to find any landmines that may be there, such as, preference payments, non-exempt assets that need to be dealt with and the like. You want to make sure you do all that. And so for a lot of attorneys, traditionally, they would do that while they prepare their statements and schedules. But with bifurcation, since you're not doing your statements and schedules until after you file the case, you can't do that. You have to do it before you file the case. And the way you do that is with a detailed and a robust intake questionnaire with your client. I think most experienced lawyers do use them. I know I talked to some, though, who have been doing it long enough, they feel they don't need it. But I highly recommend you always have a written intake questionnaire that you give to your client when they first come and meet with you. It'll help make sure you ask all the right questions and also protect you if down the road a trustee discovers they're on their title of their mother's home or something, and the client says they told you that and they didn't, and you can see clearly that was one of the questions on the form and they marked the answer no, that they weren't. So it protects you, but also helps you just flush out the issues. So again, you're still doing all the required due diligence before you file a case. And so that's make sure we're doing everything right on that. So the next thing I want to talk about is the case law. I mentioned that earlier. So bifurcation goes back at least 25 years. There's 25 years of case law, and I'm sure attorneys were being creative before that as well. But the attorneys tried lots of different things over the years to see what would work, because the bankruptcy code just isn't, for Chapter 7, just isn't set up for a clear method for collecting payments post-petition, unlike with Chapter 13's, and where it's very clear how it works. So attorneys tried different things to collect fees post-petition. One is something I mentioned earlier, is that they would just have a single agreement signed before they file the case. They'd file the case and then they try to collect payments afterwards. It's clearly a violation of the automatic stay. Yes, there are some debtors who will just gratuitously pay you anyway, but if you're going to run your practice based on that, you're not going to get very far. It's just not a good idea. Some attorneys tried post-dated checks. They would collect checks before they filed the case that were dated after the case and deposit those. And for me personally, I don't know why anybody thinks that would work, but there's multiple cases where attorneys tried that. And of course, the court said, no, that is a violation of the automatic stay. You can't do that. And then the next kind of concept that came up were straddle agreements. And with straddle agreements, the idea is you still just do one fee agreement with your client before you file the case, but at least the agreement talks about what's pre-petition work, what's post-petition work, and how much the fees are for both of those. And actually, those were accepted in a handful of states, a couple decades ago. But over time, they fell out of favor, and particularly as the two-contract method evolved. And so the two-contract method really became known, at least in 2012. And what happened in 2012 is that there were two cases, one out of Florida and one out of Michigan, completely unrelated, but both very similar. In both those cases, the attorneys used a bifurcated arrangement as we know it today. They used two agreements. They had disclosures to the client, and the U.S. trustees challenged them. But in both cases, the court held that, no, that actually works. You can collect fees post-petition for post-petition work performed pursuant to a post-petition agreement. The case in Florida, the Clark and Washington case, it really went into detail with the bankruptcy code and just walked through the process and analyzed it and came to the conclusion that it's all works under the bankruptcy code. The case in Michigan did that as well, but perhaps more interestingly, it actually dove into the rules of professional conduct and did a deep dive as to how this all fits in with clients in terms of disclosures and informed consent. And it also concluded that it works. And so that really, the horses were out of the barn at that point, and people all around the country started doing bifurcated cases. It was all going pretty smoothly. And then about 2016, a company came out that was offering some similar services to us in a much different manner, and they're no longer in business. But they got attorneys into trouble. They didn't do good disclosures. They didn't always use two agreements. There were some questions about the amount of fees that were being charged. And so some cases came out 2016, 17, even a little bit 18, where attorneys got in trouble. But in all these cases, not once did the court say you can't bifurcate. They just talked about the things you have to do it correctly, which is mostly the disclosures and charging a reasonable fee. And again, I'll get into more detail on that in a second. And then, so when we started a company in 2018, we saw the lay of the land. And so we actually wrote an article that was published in the ABI journal, I think it was June of 2018, that really analyzed the cases and again, clarified, I think, that this is all supported by the case law and supported by the bankruptcy code. And then a case came out of Utah in 2018, which has become a pretty famous case. It's the In re Hazlitt case. And in that, the judge did a very detailed analysis of bifurcation and collecting fees post-petition, and really followed our analysis from the ABI journal and concluded that is absolutely permitted by the bankruptcy code and that it's necessary. It acknowledged that there are so many debtors who can't get access to counsel in bankruptcy, and the only way for it to happen is through a bifurcated arrangement and payments being made post-petition. So it's exciting to have that case come out. And then really the cherry on top, though, was in last year, Clifford White, who is the head U.S. trustee in Washington, D.C., was giving a speech to all the U.S. trustees and talked about Hazlitt. And he commended the analysis in Hazlitt and commended that to both U.S. trustees and to attorneys, that is the right way to do this. These are the issues you have to make sure you're dealing with when you do it. And it's completely in line with how we operate. So that was pretty exciting. And then really just the last, most recent case is In re Carr out of Kentucky. It just came out in January of this year and again followed everything else. So the discussion's really left whether or not you can bifurcate, and it's really just about how you do it and what are the proper disclosures that need to be made. So let's go back to our slides. So let's talk about the keys to bifurcating correctly. It's disclose, disclose, disclose. And disclosures come in two forms. They come to the court and there's disclosures to your client. So first with your client, the rules of professional conduct are very clear on a lot of ethical issues. It really comes down to proper disclosures to your client so that they can give their informed consent to waive the conflict. And so in a bifurcated arrangement, you need to disclose to them exactly what's happening, the fact that there are going to be two fee agreements. You have to advise them that they don't have to sign the second agreement, even though they do because they like you and they want you to be their lawyer. You still have to disclose to them they have the option of not hiring you, and they could either hire somebody else or they could proceed pro se. If there's an increase in fees with bifurcation, and we'll talk about that a little bit more later too. If there's an increase in fees, you have to make sure you disclose that to the clients as well, and disclose to them the payment terms and the like, so they're fully informed on how exactly everything's going to go. If you're working with Fresh Start funding, there's a series of disclosures you make on that too, that disclose our role, exactly what we do, and just make sure again that your client's fully informed about everything that's happening. And then even in your post-petition agreement, you want to make sure you disclose to them that they still don't have to sign that agreement, and really make a lot of the same disclosures. And we have all those disclosures to make your life much easier. And then there's the court disclosures. So this is, to me, I guess, kind of an interesting area. The bankruptcy code doesn't require a lot of disclosure on this, but the case law has really evolved that you should make a lot of disclosures. So it's really gotten outside the bankruptcy code, which is totally fine, because again, you can't get in trouble for over disclosing. So the way we do this, it happens in two documents that you file with the court. The main one is the form B-2030, which is your fee disclosure you make to the court. And in that form, you're going to again disclose the fact that you bifurcated the case, make it clear that the fees you're collecting post-petition are solely for post-petition work and pursuant to a post-petition fee agreement. If you're working with us, you're going to disclose different aspects of that relationship. If you're charging a higher fee, you're going to disclose to the court that you do charge a higher fee for a bifurcated case compared to a more typical case. And again, you're just disclosing everything. And so we have a pretty big expansion on that form. It also, in the jurisdictions that have a local form that replaces the federal form, those same disclosures generally work in that, although I know there's at least one state where it works out better to still use their local form because it's very specific. You need to use that, and then we just put the disclosures into a separate document we call disclosures. So make sure we're in compliance with the local rules. But again, those disclosures are critical. And that's where most attorneys have gotten in trouble in recent cases where they just don't have any disclosures. And that's where the judges have taken them to task. The only other place you'll want to make a disclosure is in Schedule J. As you know, Schedules I and J are forward-looking. And so we do recommend that attorneys disclose the payment in the schedules. And then also there's a question 24 about future increases, and we just have a little sentence that we add to that too, just again making full disclosure to everybody involved in the case that there's an increase in the budget to cover the payment for the attorney's fees. So those are all very good. The next thing you need to deal with is reasonable fees, and so that's where some attorneys got in trouble again back in a couple of years ago, where they really increased their fees a lot. And it goes back to the old saying that, pigs get fat and hogs get slaughtered. And so, you don't want to have a $800 fee for a non-bifurcated case and a $3,000 fee for a bifurcated case. It's very hard to justify the difference in those fees. But we do believe you can raise your fees in a bifurcated situation so long as your fees are still reasonable under Section 329 of the Bankruptcy Code. And we have tools to help attorneys figure out what's acceptable. But something that's really interesting is that the fee calculator tool that we have, it allows attorneys to see too, like how much they're really making on an hourly basis in a traditional Chapter 7. So for the attorneys that are unfortunately got themselves into a very competitive area and their fees are maybe only $1,000 or less in a Chapter 7, those attorneys are really only billing their time out at about $50 an hour. And so, bifurcation gets you out of that price war and allows you to get your fees back up to a normal rate. And really many of our clients, our attorneys that work with us have raised their fees, but they're really back to where they were maybe, 10 years ago. It's not like it's a giant increase. And in fact, I'll say the average fee that in a bifurcated Chapter 7 for attorneys working with us is right around $2,300. Some are still close to $1,000, some are $3,000, but the average is about $2,300. And then just the other thing you have to be very aware of in bifurcation is that you have to make sure that the bifurcation and the post-petition payments are in the best interest of your client. And really the best way to do that is to present your clients with two options when they meet with you. Say, hey, if you can pay me up front, this is what the fee will be, and I'll get you filed after you pay me. Or if you can't pay that now and you want to make payments afterwards, this is the fee. It's a higher fee. This is the difference. This is how much your payment's going to be. Let the client decide what's in their best interest, because nobody knows better than they do for that. And then just the last thing I always say is no shortcuts, because again, I know Chapter 7 attorneys can get really busy in their practices, and it's the minute you take any shortcuts, such as signing the post-petition agreement before you file the case, or preparing statements and schedules beforehand, but then having your agreement say you weren't going to do that, you're going to get yourself in trouble too. So let's talk about the benefits to the debtors. They're pretty obvious, but with bifurcation, it allows almost everybody to be able to afford an attorney. And again, as we discussed earlier, that makes a big difference in the outcome of their cases. It also allows them to get filed right away. So if they're looking at doing a layaway plan and making payments for months or a year, this allows them to just get filed right away. The other benefit is they're going to be making payments post-petition. So they're going to be making payments after the automatic stay and discharge and injunction are in place. So they're not worrying about creditors and garnishments and the like. And it's just a much better time for people to make payments than it was before you filed the case. Also allows them to rebuild their credit with the credit reporting. And so it's some real benefits to the debtors. Let's talk about the benefits to attorneys. So with attorneys, one of the benefits is your marketing is going to be much more effective. If you want to really grow your practice and help lots of debtors, you're going to have to do marketing. And we work with marketing companies all across the country. And I know there's been some presentations this week on marketing, and those are fantastic. But everybody we talk to in the space will agree that once you're able to market either a zero or a low down option to clients, the marketing is much more effective. Because again, it shows people when they're looking for help for bankruptcy, they realize they don't have to come up with $2,000 to get a case filed. They can get their case filed right away. So they like that a lot. It also, more people will show up for the initial consultation. There's always some amount of no-shows. You talk to somebody over the phone, tell them to come in, and they don't show up for their appointment. The main reason they're not showing up is they don't know how they're going to pay you. So once you have this zero down option and they know about it, they're much more likely to show up for that initial consultation. The other obvious thing is more people will retain you. As we talked about earlier, only about 50% of the people that come into an office retain an attorney. And when you have this option, zero or low down option for your clients, you're going to have more people retaining you. In fact, almost everybody will retain you when they come in the office. And the other thing that surprises attorneys a lot is you'll get more referrals when you do zero down. And I was really surprised at first in my practice. I mean, referrals are an important part of every practice, but I didn't expect them to increase just because I was offering zero down. But what I realized was happening, though, is we'd file somebody at some company, and all of a sudden we'd start getting lots of people from the same company or lots of people from the same family would come in. And basically, they would tell each other they filed bankruptcy with an attorney. People would be like, well, how can you afford an attorney? And they explain the zero down and the easy payments for 12 months. And they would send more people into the office. So that was a great unexpected benefit. And then, of course, there's the increased fees. And we talked about that a little bit. But I want to be just really clear about this. Most attorneys that work with us do charge more for a bifurcated case than a regular case. And I think it's completely ethical and allowed under the bankruptcy code. But again, you can't overcharge. There was a case that came out of California that had nothing to do with us, but there was a law firm there that looked like they about tripled their fee. And it was just too much. Now, again, the true analysis isn't what do you charge for a normal case and what do you charge for a bifurcated case. I mean, a lot of people will frame the argument that way, but it's actually technically not correct. The real question is, can you justify the fee you're charging in either way under the lodestar analysis under the federal law? So all federal courts for decades, going back, whether it's bankruptcy court, district court, the reasonableness of fees are based on what's called the lodestar analysis, and that's just what's a reasonable hourly rate, what was a reasonable amount of time for the task done, and there's some other adjustments that can be done, but that's really the two main factors. So if you have an increase for a bifurcated case, you just have to make sure that your rate and the time you put it into the case can justify the fee that you're charging. And again, we have some tools for that to help attorneys to make sure their fees are in line, but it's something you have to be careful about when you increase your fees. So that actually concludes the main part of the presentation. I don't know if we have any questions we want to deal with.
Hey, you're back.
Hey, you're back.
Hey, thank you so much for your presentation.
Hopefully you put your pants back on.
Hey, no, every single day I've been wearing my khakis because I'm terrified that someone's going to ask me. I'm going to be like, no, I got it. So thank you for validating my choice. We do have some questions for you.
Great.
The first one I think would make sense, but it was asking if you can speak to the, I believe that's a Kentucky Eastern Bankruptcy District in regard to the CAR discussion of factoring agreements and explain how Fresh Start is different.
Sure. Yeah, so CAR is one of the cases I mentioned. It just came out in January of 2019. And actually, I guess I don't know that there was really any finance company involved with the case, but I think there might have been a reference to factoring, which again, we don't do. So let's talk about factoring, because factoring can mean lots of different things, but where it's generally considered a problem in the legal space is where you literally sell your receivable. So you're selling your receivable to a third party. So the idea is that someone owes you $1,000. You say, hey, I'll sell you this for $800. So attorney gets $800. But then this third party goes after the consumer for $1,000. So they've taken away, a lot of the ethical obligations attorney would have now shifted to a non-lawyer third party, and just creates a lot of problems. In theory, you could disclose and get informed consent around it, but most states have already said that just no, it's too complicated, don't do it. But so for us, what we do is we provide true financing. So we it's a line of credit. It's secured by the receivables. But it's we have a lien against them. So it's just like a line of credit from a bank. So you don't assign us any receivables. We don't take over making decisions about clients, any fee disputes that's between the attorney and the debtor, and we just have a lien against it. That's all.
I dropped my microphone for the second time today.
Now, is that symbolic, or is that actually a true physical drop of the microphone?
You know what? You can take it as you like. I think it's just because I'm a big clumsy person. Okay, thank you. Thanks for answering that question. Here I have the how much time has to elapse between the signing of the first contract and the second contract?
So the question really is when can you sign the second contract in relationship to when the case is filed? So the first contract obviously can be signed whenever. Case can be filed whenever. Some attorneys will figure out a way to do it the same day. Many do it within a few days. They'll get that case filed. And then technically that second agreement can be signed a second after the case is filed. And so what we do, we have lots of attorneys who have clients sit in their office while they file the case. Once it's filed, they then have them sign the second agreement. And when it's done on the same day, we just ask that they put a time next to their signature, so it's clear that if the case was filed at 1:42, that the second agreement wasn't signed till 2:30 or whatever the time is. So you can do it very quickly. You just have to make sure you document it in case a question's ever raised or someone says, no, this was signed. The second agreement was signed before the case was filed. You can prove that's not true.
Sure, makes sense. The we have time elapse. They're not numbered. I got bullet points. All right, and it's all off my phone because that's how we're doing things today. And it's asked which states allow this type of practice?
So I guess maybe the key part is allow. So the bankruptcy code is obviously federal law, applies in all 50 states and the territories. So from our standpoint, it's allowed everywhere. There's a couple, I guess we call them sort of hot spots that we're dealing with, and it's almost funny in the sense that the couple hotspots around the country, it's not even a state, it's just like one portion. So like maybe the Western District, there's somebody who doesn't like it, but the Eastern District, there's thousands of cases being filed this way. And so it's kind of strange, but what we're doing is we're being very proactive. We're not just sitting back and waiting for U.S. trustees to raise issues in some of these locations. We're actually taking the case to them. We're doing adversaries, seeking declaratory rulings that it's all permitted under the bankruptcy code. So again, it's happening everywhere. We're all over the country, but if there is somebody who's in an area that is difficult, we'll take it to the U.S. trustees and force the court to rule on it, because again, the law is 100% there.
Cool. Yeah, we have questions aplenty here for you. The next one here, and how do you handle the court filing fee?
Yeah, so you have options on that too. So and it's handled differently a lot. So maybe the most straightforward way is some attorneys will collect some money up front before they file the case. And so maybe they collect the $335 or maybe even $400 or something to cover the credit report fees. But you can collect it that way and just pay it in a normal manner. Other attorneys will not collect any of it up front, but they will go ahead and just pay it once the case is filed in a normal manner, and then roll that filing fee into the payments that the debtor is going to be making post-petition. Some attorneys do it the most complicated way, and I did this in the beginning, then realized eventually that it wasn't worth the headache, and that was I would file a application for the filing fee to be paid in installments, and then once the client came back and signed the second agreement, then I would go ahead and pay the filing fee on their behalf. But again, that creates a lot of extra work. In some jurisdictions, you can't pay through ECF on installments. You have to take a physical check down. In some jurisdictions, the courts will call a hearing to talk about it. It's just a lot of headache. And the real fear that attorneys have is just that people aren't going to come back and sign the second agreement. And the reality is everybody comes back and signs it because they signed the first one because they liked you and they trusted you. And there's no reason for them not to sign that second agreement as well.
Cool. Awesome. Let me see. We have a question here on how much does the defense guarantee and indemnity cost?
Yeah, it's very expensive. It costs you $0. So we don't charge anything for that. We even cover the fees. So we cover our travel. We cover, if there's like the adversary situation, we'll pay the adversary filing fees. It doesn't cost attorneys anything. It's just part of the package. Because again, for us, we're 100% believer that what we're doing is correct. And again, every case has said this. It's just there's still some resistance here or there in it. But no case has ever said you can't bifurcate.
Sure. Okay. This might be a little bit broad, so it's a nice open-ended question for you. But just like in general, exactly what Fresh Start Funding does and how they can help. Like I know you just went through a presentation, a good way to like in a tight package.
Yeah, so we basically help attorneys just be attorneys and not worry about all the other stuff. And so we do that again by providing a line of credit so you have cash flow while your clients are making payments for a year. You don't have to wait for those payments to pay your bills. You're going to get money up front. We manage all the payments, which I tell you is a lot of work. We have very highly trained professionals in our office and the best technology for managing all those payments. As I mentioned, we use text messaging and emailing. We have an online portal where debtors can, if they miss a payment or their credit card expired, they can just click on a link in a text or email. It takes them right there. They can update the information. It's super easy. But really the way that makes us really stand out though is the human touch. So we have our people, we actually do a welcome call for every debtor that comes into our office. We actually reach out to them, introduce ourselves. I mean, hopefully they already know who we are from the disclosures you've made to them in the forms, but in the stress, and they may have forgotten who Fresh Start Funding is. But we call them, we confirm with them that the payment start date's good for them. We confirm if they signed up for weekly payments that's actually good, or they prefer bi-weekly payments or monthly. We're super flexible and all that stuff, and we really work closely with them. And we hear just really good feedback from people that they really like working with us.
Really good. Probably as good of a time as any to remind everybody that the recording of the presentation will be available on the live stream site. But
let me add one other thing too, just make sure about our services, because the credit reporting that we provide, I know I talked about it, but it is super important. The debtors really like the credit reporting because they want to rebuild their credit, and it's also a great tool for us to help with the collections. I mean, our delinquencies are in the single digits, and it's really shocking to most people that we can collect more than 90% of the money from people who are just filing bankruptcy. But it really comes back to just the friendly manner we do it, the technology, the people, the incentive of the credit reporting. I mean, it really all works together so that we just have great results. And I'll tell you, in my practice, I was nowhere near 90% collection rate. I was more about probably 70% when I was doing it on my own. But once we were able to really have dedicated people that all they do is deal with this and technology, and we brought in people with lots of expertise in the space that work for us now, it's amazing the results we've gotten.
Well, we have a popular question here for what happens if they don't sign the second agreement, and what are the obligations of counsel?
Yep, great question. So this also ties into where some attorneys have gotten themselves in trouble. So in trying to serve their own interests, some attorneys have, not working with us luckily, but some attorneys in the past have put into their agreement that if the client doesn't sign the second agreement, that they are consenting up front for the attorney to withdraw. And that's just an ethical no-no, and it also violates a lot of the local rules, especially unbundling rules in different jurisdictions. You can't have your client agree you can automatically just withdraw. And it's you're just kind of finessing the words, arguably. But what you need to have in the agreements and what they say is, then if they don't sign it, you reserve the right to basically file a notice to withdraw. But until the court grants it, you are in that case. So you can't just stop doing work. You still have to do everything involved in the case until the court issues an order that's authorizing you to withdraw from the case. So I guess that was a long answer. The short answer is you're in that case until you're not. So you have to keep doing the work.
Sure. Makes sense. I'm still working on my bookend for after someone answers a question. I'm thinking about going with, I accept your answer, and then I can move on to the next question.
I prefer something like, you're amazing. I've never heard anything more interesting than that. I mean, you might try that.
We'll see that. Right. I was thinking maybe but no.
That's pretty good. That's pretty good.
All right. All right. I do have another question for you. How can I want to make sure this is right. Yes. How can a debtor pay an attorney in a Chapter 7 case post-petition without the court's permission?
Yeah, so that goes back to just the whole basics of bifurcation. So in a Chapter 7, they can sign a new fee agreement with the attorney. It's really no different than them going out and buying a car the day after bankruptcy. There's no court approval required to take a loan out or buy the car. They can just go do it. And so with bifurcation, it's really the same idea. Once a case is filed, they can sign a second agreement with you. That second agreement is not subject to, it's not part of the bankruptcy. It's not going to be discharged. It has nothing to do with the automatic stay. You don't need any kind of court approval. So it's just an agreement that's made, and you collect those payments. And really on that, if to some people have more questions about the law, and if we don't get to them here today, we've done some really good webinars that really do a deep dive into the case law and the rules and the like, and they are available on our website. And so there's a lot of information there, and we have lots of written documents we can share too, and the cases and the like. So love to share it.
What a phenomenal answer! Like, it was out of this world.
Let's take it down. Take it down just a little bit.
No, you deserve it. You deserve every bit of it. No, you're right. I do need to tone it down, or else I'm going to smack my microphone again. All right, and we have about a minute here. I'm going to see. There were a couple of questions left. I'm going to give you one more question, but also remind everybody, like Matt just said, that they do have some webinars available. So hopefully that can answer any questions that we might not get to. Here, let me see. I'm trying to find a juicy one. I'll go with, can my clients use your services for IRS and state tax collection cases?
Well, the answer is if they're being handled through bankruptcy, then the answer is probably we can. We want to talk about it, but if it's not within the bankruptcy context, then no. Okay.
Oh, wait, we still have like another 30 seconds. And how do you get past? Here we have how do you get past the attorney appearance rules? My understanding is it is very difficult to withdraw. So what happens if the client doesn't sign the second agreement? What are you bound to do? So it kind of ties into that previous question.
Yeah. So again, you're still bound to continue with the case until the court lets you out. And yes, especially some in the areas that have usually referred to as the raws, the local rules that state specifically what you have to do. You may not get out of the case, but what I found is it's so rare for someone not to sign that second agreement. And if they don't sign the second agreement, they typically never come back anyway. So, when they come back to sign the second agreement, they're either also reviewing at that point the statements and schedules and signing them so they can be filed, or maybe they're coming back another time for that. But you cannot, as the attorney, file the statements and schedules until that person reviews them and signs them. And so, for someone to not sign that second agreement, but be willing to come to your office and sit there and review statements and schedules and sign them I'm sure somebody that would do that, but I've never seen it. So in the cases where someone didn't come back, the cases would typically just dismiss on their own, because I literally cannot ethically file the statements and schedules because they've not been reviewed and signed by the debtor.
Sure. I think we're getting pretty close to time, so this would be a good time to couple of things. One, thank you again so much for joining us today, for putting the effort into this presentation, and also regaining that momentum after I jumped in a couple times. I hate interrupting. It was just a little choppy for a minute, but
no problem.
Any other closing thoughts that you might have, or resources?
Yeah, for sure. So I tell you, I really encourage attorneys to adopt this in their practice. Even if you think it's going to be a small piece of your practice, it can really help you. I think you'll find no matter what, though, it becomes a big part of your practice. It's very easy to sign up. We have phenomenal training to make sure that you and your staff are doing this correctly. We call our lunch and learn. We'll buy lunch for everybody in your office to watch some training of videos, and then we'll have a live Q&A with our staff to go through everything. We'll make sure your forms are correct. We just do everything you need. And I see there's a phone number up here. At the end, there'll be a number 2, but I think you can probably see it here. We have staff available to take calls. I'm available to take calls. We have just a lot of expertise here at Fresh Start Funding, and we'd love to talk with you and answer any other questions you have.
Thank you so much. And some closing notes for everybody else. This presentation, as well as all previous presentations, and the future presentations after they've run, they'll be available. The recordings will be available to check out later on your own time. I'm checking my messages to make sure I don't forget anything big. Janine, Sarah, this would be the time. Good. Mandy. All right. Thank you again so much to Matt. Thank you, everybody, for joining us. Our next session will be Marketing Your Law Firm with Jim Christie at 3 o'clock. And really hope to see everybody there. We're on a webinar. Thank you again so much, Matt. We really appreciate you being here. We appreciate everybody being here. And I'm gonna wrap up the webinar now.
All right. Thank you.
Thanks.